Hello, everyone. Thank you for joining the Whitkin State Law Library, part of the California State Library, for a special program on trial and error, what popular media gets wrong about trials with Connor Johnston. My name is Kimberly Sims, and I am the host of today's event, rather. I am a reference librarian in the Whitkin State Law Library of the California State Library. We have a co-host tonight, Elena Smith, another librarian with the Whitkin State Law Library. Elena will be monitoring our Q&A section throughout the talk for any questions you may have for Connor, and she will read your questions during our Q&A session at the end of the presentation. Vanessa Chrisman, who is the head of both the law and government publications sections here at the State Library, is also on this webinar. This program would not be possible without the support of the California State Library Foundation, for which we are eternally grateful. To learn more about the foundation, you can visit their website at cslfdn.org. Before I go any further into our program introduction, I also want to acknowledge that I work on the unceded ancestral homeland of the Nisenan and Miwok peoples, many of whom continue to live and work here today. As such, I am a guest on this land, and I want to acknowledge, thank, and honor my hosts. The California State Library is thrilled to have Connor Johnston here to discuss the major myths in popular culture about trials and give a peek into the true practice of law. It promises to be an exciting and interesting talk. To make sure that you have the best experience possible, I'm going to have to go over a few technical housekeeping details, and then we'll get to the presentation. If you have any questions during the presentation, please type them into the Q&A section, and we will answer them at the end of the program during our Q&A session. This presentation will be recorded and made available after the talk. Live transcription is enabled, so if you'd like to see the captions, click the CC icon to show subtitles. If you run into any technical difficulties during the presentation, please put those in the Q&A section and we'll try to help you if we can. We've added links to the California State Library in the chat window. For any state employees without a library card, please consider applying for one through the posted online application link. And don't forget to register for one of the state library's many other programs. Please enter your questions or any technical issues you may have during the program into the Q&A session. We will be monitoring questions throughout the program, and they will be answered during the Q&A session at the end of the demo. Connor Johnston is an attorney that has had experience in nearly every type of legal practice. He currently is a senior appellate attorney with the 3rd Appellate District, where he has helped justices review hundreds of civil and criminal appeals on many different legal issues, and many of these cases are appealed after a trial. Before joining the court, Connor worked as an attorney in private practice at firms big and small, in both transactional and litigation practices, including preparing cases for trial and arguing motions in court. Connor is presenting on his own behalf, not as staff of the court. Please join me in welcoming Connor.
Hi, everyone. Thank you so much for having me and for that great bio that I definitely did not write. As I mentioned, my name is Connor Johnston, and I'm presenting today a presentation I'm calling Trial and Error, What Popular Media Gets Wrong About Trials. So I first want to start off expanding a little bit on my bio so you can have some context on what the experience is that I'm relying on. I have had experience, as I mentioned, in big law firms and small law firms doing transactional and litigation work, and I'll talk about what the difference of that is in a little bit. But my most relevant experience I'm relying on today is as a senior appellate attorney with the 3rd District Court of Appeal. I want to explain what that means a little bit. So I'm going to assume most people here on this don't have a vast legal experience, so I'm going to try to give a little bit of a background on not only the law while I'm talking about the media, but also not only trials, but also about law general. And so the appellate court here in California, we sit between the trial court and the Supreme Court. So if anybody in our district, which covers Sacramento County, Yolo County, San Joaquin County, and all the counties basically up to the Oregon border and all the way to Nevada, if you don't like what happens at trial, you then appeal to our court. And we have to hear every case that comes to our court. If you don't like what we say, then you can appeal to the Supreme Court, but they don't have to hear every case, and they usually don't hear that many. So we're the last stop for a lot of the cases within our jurisdiction. And because of that, I've reviewed hundreds of cases, both civil and criminal, and a lot of those cases come after trial. So I've read literally thousands of pages of trial transcripts as I've been reviewing these cases, and that's both civil and criminal. And I also want to note the judge I work for is watching this, and he'll definitely make sure to note if I get anything wrong in this. But I really want to note that I don't have any media and film experience. This presentation is largely just based off things I complain to my wife about when I'm watching TV and movies and say, that's not how it happens. And so this is my opportunity to really explain to a certain degree what I think really happens in trials. I also, so if you're looking for, a sophisticated media analysis, this is not the talk, and I'm sorry. It's definitely more of a legal analysis and a novice media experience. I also feel like I have to note that this weekend's my birthday, so I shamelessly hope you like this presentation a little bit more knowing that fact. So as a lawyer, I have to include a disclaimer. Everything I say, as they mentioned, is my opinion, not the courts or any of the justices on the courts. And nothing I say should be construed as legal advice. This is supposed to be educational and hopefully just a little fun, but it's definitely not like law school, right? I'm not trying to teach you, the ins and out of the law, and this shouldn't be considered legal advice. So getting that out of the way, this is the overview of kind of the myths that I want to talk about that I have developed in my vast expertise of watching movies and TVs involving law. And trials are a really important part of the legal system, but I truly believe that pop culture's understanding of the trial process and its prevalence in the legal community is misguided in many serious ways. So this presentation will discuss 6 myths. There definitely are more than we have time for. And if you talk to any other attorney, I'm sure there's a lot of attorneys on this as well. I'm sure you'll disagree with this list, add more, subtract some. I'm sure there's a lot more. These are just myths that are noteworthy to me. And again, ones that I know my wife would pointing out. But the list is definitely not exhaustive, and I don't want to make it seem like it is exhaustive. I also want to note, I don't want to be too much of a curmudgeon. I know entertainment is supposed to be dramatic. That's why it's entertaining. I know movies and TVs dramatize a whole host of other industries, not just law. But I do think the trial is a crucial part of our system. And so I do think it is important to have an accurate basic understanding of how it actually operates. So these are, again, the myths that I find most important. And there will be questions at the end. Obviously, feel free to ask any questions about the presentation, but I'm also open to talking about any questions about the legal practice in general, law school, anything like that. I'm happy to go into it. So my first slide, I do want to have a quick trial primer on the structure and purpose of trial. Again, I'm assuming not everyone on this webinar actually knows what a court trial is and what is kind of the point of it. So these are kind of the 3 main buckets that I first wanted to talk about to just give you basic understanding. First, trials are the means we resolve disputes in the United States, the way that we do it objectively and equitably, deciding deciding if a law is broken and what happens after that. That may seem obvious, but it's a really important point that when there's a dispute, people don't just throw rocks at each other. They have to come to court in order for there to be a legal resolution. And the way that we resolve that is ending ultimately in trial if there's not a settlement beforehand, which I'll talk about. Now, there's also 2 main types of trials, which is also kind of branches off of the 2 main types of legal practice, criminal and civil. Criminal is if you break a law, a penal code law, and if the result of that is you go to jail or have your freedom restricted in some way, maybe probation, that type of case, criminal cases, the prosecuting party is the government. It's often the DA, the district attorney, also called the people. They are the ones that are prosecuting violations of criminal law. And that in a trial must be proven and established beyond a reasonable doubt unanimously by the jury or a court trial, which I'll talk about in a second. That's very different than a civil trial. Civil trials are private parties that are arguing over something that's just happening between them that the state doesn't have a direct interest in. And the result of that is usually if you lose, you pay the other party money or you're forced to stop doing something. But it's the private party that is litigating it. And there, the standard of burden is the preponderance of the evidence, which is basically more likely than not that it occurred. So it's a very different standard to be able to prove your case in a civil trial versus a criminal trial. Finally, the fact finder in a trial. Oftentimes people just assume all trials are done by juries, and they often are what's called the fact finder. The fact finder is the entity that ultimately decides what happened. They see the evidence and they decide, oh, I think the light was red. That is the ultimate decider of the facts in the case. But you can also have a court trial. This isn't often seen in media, but the judge the judge in a jury trial is often more ministerial, making sure the rules are followed, that the evidence is being properly admitted, but they're not ultimately making the decision of guilt or innocence or who's right or wrong. But sometimes they are if the parties agree to a court trial, and that means the judge will sit as the fact finder. So I just want to get this out of the way just so you have a basic understanding of the structure, just assuming not everyone fully understands kind of the nuts and bolts. And again, I'm happy to answer more questions about that down the road. But let's get to the myths. So the first myth that I've come up with is kind of the big one, in my opinion. It's underlining kind of all the other ones, is that trial is simply just central to being a lawyer. So in media, when you think of a lawyer in media, in a movie or TV, you think of them being in trial, making objections, examining witnesses, arguing to the jury, presenting evidence. These are all things that are done in or around a trial. And media, there's the Law and Order sound. So media, I could put a dozen more examples up here, but these are some of the famous ones, right? To Kill a Mockingbird, that's all about a trial. Law and Order is always about a trial, generally, from the episodes that I've seen. The lawyers are either in pre-litigation or going into litigation. It's a little different because that's criminal, and DAs generally, that is their job, is to litigate. But even private practice, like in LA Law and some other movies and TV shows, you associate lawyer equals trial. And that is just not the case in reality. Very, very little of most attorneys' careers will actually be spent in trial. So first and foremost, I want to kind of take a step back and talk about the difference between litigation and transactional work. If you're not a lawyer, you may not have ever heard those terms. So litigation is working on a disagreement with the possibility of trial. There's been some wrong, and you are hired to help get a remedy, a damages on behalf of your client because there's been a wrong. So in my private practice before joining the court, I did general business litigation. For instance, I had a client who thought they were in a contract with another party, and the party breached that contract. And they come to us and say, I've been wronged. I need this to be litigated. That is with the idea of going to court, and that's called litigation. The other whole half of potential legal practice is called transactional. That's helping parties avoid future litigation. So again, for instance, my personal experience, I was a transactional attorney for startup companies in Silicon Valley, and I did a whole host of things like negotiating contracts, helping form business entities, helping companies raise money, protecting IP. These are all things that you do to help your clients avoid future litigation. And transactional attorneys should never go to court because that's not their specialty. It's like a fish out of water, right? You don't see a fish walking because transactional attorneys, they aren't litigators. They want their clients to avoid litigation. And if their clients get sued on something they do, then they hand them off to a litigator. But I want to drive this home is that a lot of attorneys don't even do litigation. So trial does equals attorneys doesn't even make sense for, I think, probably half of attorneys. I don't know the exact split, but there's a lot of transactional attorneys. But even if you are a litigator, few cases actually end up in trial. So there's a lot of statistics out there, but the ones that I have found roughly somewhere around 3% of cases filed actually end up making it through trial. And there's a lot of reasons for that. First and foremost, the vast majority of cases settle before trial, or in criminal, it's called pleading out, where the defendant just admits to committing a crime instead of going to trial. or the cases are dismissed pre-trial and either motions for summary judgment or other ways to dismiss a case before trial, or they go to arbitration or another form of alternative dispute resolution. A lot of cases are. So even if you're a litigator, most of a lawyer's day-to-day isn't in trial. It's sitting and checking emails and phone calls like most other professionals. That's look is probably not too dissimilar from faces that I may or may not have made while in private practice. It's a lot of being just sending emails back and forth between opposing counsel, co-counsel, other associates in your firm, your client, and then you are doing legal work and writing up briefs and motions for the court or propounding discovery requests to the other side. But very, very little of it is actually in court arguing, which is what media shows attorneys doing in my experience of watching TV movies, is that you really associate attorneys with trial. And that's just not true. So I kind of cheated here and I added a sub-myth while I was preparing this presentation because I think there's a really important sub-issue to the idea that attorneys are always in trial, and that's that attorneys actually want to go to trial. I think that's an assumption for a lot of people. If you're a good litigator, you don't want to be scared of trial, but good attorneys also want to avoid trial sometimes because they know it can be a gamble, even if you have a strong case. Our legal system is really good at reaching a fair resolution as best it can. But trial is ultimately an imperfect process because it involves human shortcomings, witness memory and convincingness, jury attentiveness and abilities. There's also a lot of just subjectivity baked into the legal system. So, for instance, if you have a negligence case, let's say there's a car accident, you're going to have to convince the jury that the defendant was acting unreasonable. And what is unreasonable to one person may be reasonable to another person. So there's a lot of subjectivity in the legal system in proving that someone did something wrong. And so I have a little activity here that I've incorporated into this. This specifically goes to witnesses' memories and the inherent weakness of trials being able to, quote, find the truth, accurately perceiving an event, remembering that event, and then testifying to that event years later. There's just a lot of room for error in that process. So this video I'm going to show you, and there should be sound to it, but you don't actually need sound. You just watch, and there's actually writing so you can see it. But I want you to pretend that you're going to be testifying in trial about the event you're about to see right after you see it. So watch closely. And there's a lot of people here that might have seen a version of this video. I still highly recommend you try to watch this as closely as possible and see if you would feel comfortable testifying about this event after it unfolds.
The monkey business illusion. Count how many times the players wearing white passed the ball. The correct answer is 16 passes. Did you spot the gorilla? For people who haven't seen or heard about a video like this before, about half missed the gorilla. If you knew about the gorilla, you probably saw it. But did you notice the curtain changing color or the player on the black team leaving the game? Let's rewind and watch it again. Here comes the gorilla, and there goes a player, and the curtain is changing from red to gold. When you're looking for a gorilla, you often miss other unexpected.
So I watched this in law school in the context of criminal law, where there were a lot of cases where the witness to the crime, the victim of the crime, was confident of the defendant's identity being the perpetrator of the crime. And the defendant was convicted purely off of that witness's testimony. But later DNA evidence discovered that the defendant possibly could not have been the perpetrator of the crime. And so this video, I think, goes to show that we are imperfect. So trial is therefore an imperfect process. If I asked you to testify to this event, you might have gotten the passes right. But what if I asked you if you saw a gorilla or the curtains changing or somebody leaving? These are all really important parts of this event, but our minds aren't able to completely perceive accurately what happened. Imagine if that was a shooting or some other chaotic event where there's a lot of things going on. Piecing those together is difficult. And so trials and the legal process in general, there is a little bit of randomness, and it doesn't always necessarily discern the truth. Even good cases can lose and bad cases can win. But good attorneys still really want to seem ready and willing to go to trial, especially if you're a good litigator. Some people do love trial. I know some attorneys that love going to trial, and it gets they really like it. But it's often a negotiating tactic because there's a lot on the line, and trials are usually an all or nothing proposition. Either you win or you lose. And settlements allow a more nuanced resolution. Trials are also very expensive. If you're going to trial, your attorneys are spending a lot of time prepping the case and then arguing the case. So you're spending tens, if not hundreds of thousands of dollars. So sometimes it's best, you're doing a disservice to your client, even if they have a good case, to say, let's go to trial, because they may win less than what they're paying you to litigate the case. So in short, this 1 and 1B myth, I just want to drive home that trials are as good as I think we can get at discerning the truth, but it's not perfect. And good attorneys know that. And so I think media has a hard time of displaying this nuance of the trial utility and an attorney's willingness to roll the dice and go into trial. And so those are kind of the main myths that I want to drive home here. All right. Next is a little bit more of a fun myth. Popular culture is replete with surprise witnesses, surprise evidence, or surprise testimony. I do have an audio example here, so pay attention.
Want answers? The truth can't handle the truth.
So I assume most of you know this reference. This is from A Few Good Men. It's a climax of the movie where the colonel, played by Jack Nicklaus, is admitting on the stand to the attorney, Tom Cruise, that he ordered the act that led to a soldier's death, which was a surprise to everybody. The same thing happened in Legally Blonde, a great legal movie, in my opinion. No sarcasm there. She gets a witness to admit on the stand that she killed the victim. And then in My Cousin Vinny, the attorney's wife is called as a surprise expert witness to testify about cars. The truth is, trials, there should be no surprises. Trials are like plays where everything is scripted. The only people that don't know the script should be the jury. But all evidence, including witness testimony, that's going to be presented at trial must be disclosed before trial through discovery. The parties can argue over what is admissible and what's not admissible through what's called motions in limine prior to trial. They're arguing this evidence isn't relevant or it's prejudicial, but there shouldn't be any evidence that is permitted to be admitted during trial that the other party was not aware of. That's often grounds for a new trial. There are things also that attorneys can do to limit the surprises and the impact of surprises at trial. So for instance, objections, which I will be actually talking about next, so I don't want to spend too much time there, but also impeachment. If you're not in legal practice, you probably don't know the word impeachment. This is, in a lot of civil cases especially, you get what's called depositions before trial, where you're bringing in witnesses that are going to testify likely at trial. And it's usually in a conference room, but you have a stenographer there and you put the witness under oath and you ask them what happened and you try to get their testimony on the record. And if that diverges from what's testified at trial, you can impeach them. So let's say, for instance, that a witness in deposition during a negligence action, I saw the light was red, but the driver drove through the red light. But then at trial, the witness says, oh, the light, I'm pretty sure it was green, so the driver had the right of way. Well, that's a surprise to you, right? Because you were told by the witness under oath that the light was red. But what you can do is say, well, isn't it true that you gave a deposition under oath prior to trial? Yes. And then and isn't it true that you said in the deposition that the light was red? And so the jury will then at least get to hear the prior testimony that was in the deposition, limiting that quote unquote surprise. But even that should be rare. Most of the time that I've seen witnesses diverge from prior testimony, either in interviews with police officers before, it's just a memory issue. It's been years since the event happened, and their testimony closer to the event is clearer. But so that means trials just shouldn't have a lot of surprises or any surprises at all. But that doesn't mean that trials are boring. The jury doesn't know what's going to be said, and it's often dramatic facts that are being testified to in trial. The parties are in a fight about something. There's been months preparing for trial. There's a lot at stake, in civil, thousands, if not millions of dollars. In criminal, potentially the defendant's freedom is at stake. And my job, reviewing cases can sometimes be like reading novels. You're reading this witness testimony, and it's very interesting facts, even if sometimes depressing too. But I want to make clear that interesting and surprising are two very different concepts. A trial can be interesting, but it should not be surprising, at least to the judges and the parties involved. And one of the easiest ploys that I've seen media do, and TVs, especially in movies, for trials, is throw in a bunch of surprises to make it more dramatic. And that just should not happen in a real trial. All right, moving right along. And relatedly, the third objection, or the third myth that I often see, is that trial is portrayed as constant objections between attorneys back and forth. And I will have another quick clip right here.
Your Honor, I object.
And why is that, Mr. Reed?
Because it's devastating to my case.
Overruled.
Good call.
So that is from one of my favorite movies as a kid, Liar Liar, where Jim Carrey plays the main character, an attorney who, through some magic, cannot lie. And so a witness says something on the stand that he doesn't like, and he can't think of a valid objection because he can't lie, and he just objects to it being bad to his case. In Suits and all the other cases, Lincoln Lawyer, The Practice, all the examples, there's often trial. When there's a trial, attorneys are objecting all the time. But the truth is, objections should be rare if everyone is following the script that's been agreed to prior to trial. Objections are most often ways to challenge something that happens during trial that is not conforming to the pre-agreed script. It's not like Liar Liar where you can just object because it's bad for your case. And much like the previous myth I talked about, there should not be many, if any, surprises. So generally, objections are often when an attorney states a question improperly or is trying to maybe slightly bend the rules, but something is happening that is off the script, as I like to call it. And so, for instance, like argumentative, the lawyer is just asking a question in an argumentative way and basically not being nice. So they just have to reframe it in a nicer way, or leading. On direct examination, when you're examining your own witness, you cannot lead. You cannot. So I cannot ask the witness, you saw the light was red, right? That's posing the answer within the question, and you can't do that on direct. So you just rephrase the question and say, what color did you see the light? That's as exciting as a lot of objections get. They're just rephrasing the question or rephrasing the response. There can be strategic uses of objections. I know some attorneys use them to throw off the other side, especially when they're getting into the meat of their inquiry with their star witness, and they just throw an objection to get them off balance. But judges and juries can get annoyed very quickly and it may not work out for you strategically, even if there's a valid basis for an objection. A lot of that is you don't want to seem like you're hiding something. And if you're constantly objecting and objecting and objecting, the jury is going to think that you're trying to hide the truth, and that's obviously not great. And juries also, I think, pay attention more when someone is objecting, because that means the parties are fighting over something interesting. So you may be doing yourself a disservice if you're overly objecting in that way. And obviously there could be legal ramifications for the attorney as well. If they're objecting without a basis, if they're doing frivolous objections, the court can hold them in contempt or disbar them if they continue to just try to throw wrenches in the proceedings just for the sake of objecting. So there's a lot of procedural protections where you shouldn't have to be objecting constantly. So in short, I think objections are an important way to keep the trial on the script, but they should not be happening. They should be happening infrequently, else something has gone wrong with the trial. All right, moving next to my fourth myth that I see often. This is more of a misrepresentation than it is a myth because it's not very overt. But in the media and movies and TVs especially, it seems like cases are resolved quickly. You know, they're often done in one movie or one episode from injury to resolution. Law and Order, again, making another appearance, I think is one of the biggest offenders of this, because every episode that I've seen goes from the crime happening, then the police are investigating, and then there's the attorneys litigating it, and then there's a jury verdict, all in one episode. The practice suits, all the cases, all the shows that I've seen where there's a trial involved, there's usually they want it up in a nice bow, right? They don't want you to have to remember everything between episodes, and even a movie sometimes is not enough. Like, for instance, in Erin Brockovich, though it is based on a true story, the reality is you just cannot show the length of a case in the time it takes in a movie. And it's obvious, but especially in a complex tort action like Erin Brockovich, where there's hundreds of defendants, you have to do probably a lot of scientific analyses. There's just a lot of work you have to do that they just can't show in the movie. Nor would I want to watch that movie, to be clear. I don't want to watch other attorneys conducting discovery on complex tort cases. But that's a big part of a trial, is getting ready for it. So in truth, justice is slow, and that's for a reason. So the justice system is more concerned with getting it right than getting it done fast. There's a difference here between civil and criminal, because criminal defendants do have a constitutional right to a speedy trial, which can really speed things up quickly. But even then, it seems like a lot of defendants waive that for various reasons. But even if you don't have, even if you are in civil, most civil cases follow this is my kind of draft case timeline of what it takes to litigate a case from injury to final resolution. So first is the injury or harm. Something bad happened and you've been wronged. Again, civil, that's like a breach of contract or a theft of trade secrets, or a trespass. And criminal, a crime happens. That kind of starts the case. And then there's the pre-litigation. It's usually an investigation. What happened? Who saw it? Who's involved? What evidence we might need to gather? But even if you're in this, you might not go to litigation, because there's a whole host of reasons why, actually. If there's a strong case on either side, you're obviously in the wrong, or the other party is obviously in the wrong. They might just want to negotiate to avoid litigation. They know they're going to lose in court, so why spend the tens, if not hundreds of thousands of dollars in attorney's fees, telling the jury what they already know? But there's also a lot of things you can do to avoid litigation. For instance, in private practice, we would send what's called cease and desist letters. So if there's someone, for instance, infringing on your intellectual property, let's say I'm Disney, I never worked for Disney, but imagine I'm Disney and someone's using Mickey Mouse to sell hamburgers. You can send a cease and desist letter. You don't want to sue them because it's probably not worth your time, but you want to protect your intellectual property. So you're sending them letters and giving them a chance to stop violating the law. And if they don't, then you might sue them. But there's a lot of things you can do to avoid litigation. But after you've done that and you still haven't met resolution, then you file a complaint in the court saying, I am suing so-and-so for these causes of action. And you have to do this within a certain time frame. It's called the statute of limitations. And the clock starts at the time you discover the harm. And that's typically about 2 years, depending on the cause of action, that you have to file the complaint in order to save your right to sue someone. And if you do it after that, it's a complete bar to your lawsuit. Okay, now you file the complaint. Now you get the fun of discovery. Discovery is probably the longest process for most cases. It's the act of accruing the facts to build your case. So that is, it's called propounding written discovery, such as interrogatories or requests for admissions. You're asking the other side to give you stuff. You can also be doing scientific analysis if that is relevant to the case. You're also doing a lot of depositions where you're interviewing people under oath with a stenographer. And I think the library is doing a webinar next in November about depositions if you want to learn about more. They're a really important part of getting your case ready for trial. But fun fact, discovery is a big part of the reason why I did not love private practice. There'd be so many times where the opposing party would refuse to give me something that I know they owed me. It was relevant. It was within the cause of action. There was no privileged information. It wasn't confidential, but it was not always in their interest to immediately hand it over. So they play games. It depends on the attorney. Sacramento, I'm based here in Sacramento. Attorneys are generally pretty great, because you get a bad reputation if you're not, but they can still play games. And so you have to send a meet and confer, and then you have to threaten to file a motion to compel the court. It's a lot of work. So after you get through discovery, then you can file pre-trial motions, which is like motions for summary judgment, where you're saying, look, we have all the facts. We agree on all the facts. This is just a legal issue. Judge, decide this. We don't need to have a trial because we all agree on the facts. There's other pre-trial motions that you could do to dismiss the case before even trial. So let's assume you get past that too. Then you go to trial, which is, as you can see, one of the shortest parts about the process. And the length of trials can vary widely. My guess is that the average is probably around a week, maybe. But they can go a lot longer. The judge I worked for when he was a Superior Court judge said he had a case that went for 6 months. So they can go a long time, but that's definitely the exception, not the rule. Most of the time, they're pretty short, maybe a couple weeks, maybe a month at most. So it's a very small part of the overall case process, as you can see. In some cases, don't even go to trial because they're in what's called arbitration. If you've ever signed a contract with a major company, really any company, you have likely agreed to what's called an arbitration provision, where you agree that everything you do, if you're bringing a case, you have to bring it in arbitration. And that is a non-judicial way of resolving the dispute. So even if and you might even litigate the validity of the arbitration provision before you bring the case in arbitration. We've had those cases where they say, the defendant is arguing that I have agreed to arbitration, but I haven't. So I'm going to argue that I don't even have to go to arbitration. And then finally, even if you make it past that, then you can appeal, which comes to us, right? If you're in our jurisdiction. So, and that takes usually at least a couple of years, because you have to file the record with the court, then you have to file your opening brief, and then the respondent's brief, and the reply brief. That takes some time before you get resolution, and then you can appeal to the Supreme Court too. So real quick personal story. When I was in private practice, I filed a complaint in 2018 for a trial that was resolved in 2022. I wasn't involved in that trial. I was already at the court then. The appeal was filed in December 2022, which we didn't work on, but briefing concluded June 2024. The appeal opinion filed in November 2024. And then the petition for the review with the Supreme Court was denied in 2025 years. So that's 7 years from the complaint being filed to final resolution from the Supreme Court. And there was a lot of work done before the complaint was even filed. So it's probably even 8 years between injury to resolution. So I bring this all up to say the media can't really portray the length of a judicial resolution or a legal resolution. But you should know, if you want to sue someone, it's likely going to take a long time to get a result, especially if it's a big case. All right, I know we're heading. I want to make sure we have enough Q&A, so I have only 2 more minutes left. And this one is a really short one. It's kind of a funny one. that I just notice when I'm watching TV and movies, there's always people in the audience at the court. And that's not, that's just not what happens. People have better things to do than watch trial during the day. Trials happen often, they have to happen during work hours. And even if it's exciting subject matter, most of the testimony is background or technical. So this is a short myth. There's just never, it's very, very rare that there's just going to be random people in the audience watching trials. But this does go into my sixth and final myth, because I think you should, I'm talking to you, should be spending your free time watching trial as a juror. So my sixth and final myth is that jury duty is often portrayed as being something you should avoid. And disclaimer, this is a personal soapbox to convince everyone on this webinar that they should be excited, or at a minimum, proud to be on a jury.
I really think it's fair for me to be on a jury because I can read thoughts.
Dismissed.
So that is from a show called 30 Rock, where the main character, Liz Lemon, dressed up as a Star Wars super fan and pretended that she could read thoughts to get off a jury. The Simpsons, there's a famous episode where Homer is on a jury and wears these glasses to make it seem like he was awake so he can sleep during jury duty. And then the last one is a little different because it's actually kind of exciting. The guy in the middle, it's called jury duty. The guy in the middle thinks he's on jury duty, but everyone else, all the other jurors, the witnesses, the attorneys, the judge, are actors acting out a trial that is just crazy. And he's stuck in the middle thinking it's actually a jury. So I'm not going to pretend that jury duty is the most exciting thing ever. Look, I have been trying to get on jury duty forever, and I've been unsuccessful. But I've spent a lot of time just sitting around, right? And that's what the image of jury duty, sitting around. But it is very important. As I mentioned before in my trial primer, the jury is the ultimate decider of fact. I know I just spent the entire presentation telling you how less exciting trials are than reality, than in TV. But there are some really interesting aspects. They are fighting again over something, right? They've spent months, thousands of dollars potentially preparing to be in trial for the jury to decide who is right and wrong. And so in jury trials, it's not the judge that's making the ultimate decision, it's the jury. And so I hope that's the main pitch for you to be on jury duty, is just the power that you have to decide who is right, right? But I also want to argue something that is definitely never really portrayed in media, at least to my knowledge, is something called jury nullification. And it's a very important part of being a core civic duty of being on a jury. It's even more, being on a jury, even jury nullification aside, being on a jury, I think, is more important than even voting. And I say that as someone who's worked on a number of political campaigns. It's just a really important role. And one of the importance of being on jury duty is potentially jury nullification. Again, I've never really seen this portrayed in the media. It happens when the jury votes not guilty, even though it's obvious that the defendant is guilty. And they do that for some reason beyond just the enforcement of law. Parties can't argue for jury nullification, and the judge will never instruct on jury nullification. It's a little bit of a cheat code, because the jury doesn't have to give a reason for acquitting someone. They can just say not guilty for any reason that they want. And these are three kind of historical examples on the slides that you can read for yourself of where the jury decided for one reason or another that even though it was clear that a law was broken, that they didn't want to impose a retribution on the defendant for doing it. And so this becomes an important check on our government, right? This is a little safety hatch that's been incorporated into our Constitution, in that the jury can ultimately find someone not guilty, even if the government brings a criminal case against them. Now, when you're on a jury, I want to be clear, it's your obligation to follow the law. And it's very, very unlikely for you to ever be on a case involving fundamental rights where jury nullification may be an issue. It very likely won't be, but it might. But more importantly, you will be on a jury deciding who is right and who is wrong in a different context. And so I think media often misses these fundamental points of the importance of being on a jury. So in short, I hope that I've turned this successfully into a pitch for you to be excited, or at least understand the importance of being on jury. And I always tell people to remember, what if you were a party in a trial? Hopefully you're never a party in a criminal trial or even a civil trial. But if you are, you really want to make sure, you would really hope that the jury is awake and paying attention and engaged and understanding the importance of their role. All right, so with that, questions. I've made it with 15 minutes left, and I would love to hear if there's any questions. I haven't been following along with the questions, to be completely honest, so I hope Alina can help me out with that.
Absolutely. And we do have questions for you. The first question that we've got going is, may we access and review these slides after the webinar? Lots of useful terminology demystified.
Oh, yeah, I'm fine with sharing it.
Excellent. Then we will send it out with the recording.
Great.
You have to
Happy to
just
share
send it
that.
to me. Okay, another question. Someone is curious if civil or criminal trials cost more.
Cost more is an interesting way to phrase it, because it depends what you mean by cost, right? In criminal trials, very few defendants are paying for the cost of trial, because they don't have to pay to litigate that they are not guilty. They often have appointed counsel, someone from the public defender's office. If you have a lot of resources, you can hire a private attorney. So for the private parties, criminal can be free in theory. But that doesn't mean that it's free overall, right? Because the judicial system costs money, it costs taxpayer money to run a court system, and it's expensive to run a court system. You have a lot of really qualified attorneys, dare I say, working in the court system. Obviously, the judges are very experienced attorneys themselves, and the court reporters, the clerks. There's a lot of staff involved, even on criminal side, that costs money, but they cost taxpayer money. So if you're talking about costs in that sense, it depends. But if you're talking about, what it's going to cost for a party, it's very likely civil, because you're in civil, you're not guaranteed attorney, you're not given an attorney, so you have to find private counsel, and private counsel is not cheap. And so every party in civil litigation is paying usually a lot of money to just litigate just a normal trial. But then if you add expert witnesses, they cost a lot of money. You're doing investigations, especially scientific investigations, those cost a lot of money. And then you're talking about damages, right? Oftentimes civil cases that are well litigated that involve big parties, millions, sometimes billions of dollars. So it really depends on when you talk about cost. No trial is free in general, but for criminal, the parties don't have to pay. Civil, the parties do. So I would say probably civil. I assume that's what the questioner was asking.
Great. Thank you so much. Okay, another question that we got. And this is related to press coverage, how easy or difficult is it to keep press or from covering a trial or allow press in? The questioner was thinking about a sexual assault case with a powerful defendant and the press really pressing basically the victim as a witness to and kind of central character in the story.
Yeah, that's a good question. And that is not something I have direct experience with. So the best way I can answer is, in general, trials are public. They're public interest. They need to be public. It's rare, though, for there to be a case where the media is interested in. So I would say it's the exception, not the rule, that media is even first and foremost even interested in a trial to send somebody out to sit in trial and take notes or even film it. That doesn't mean it doesn't happen. It does. But there has to be good reasons to not make it public. And often, from my understanding, this is a question that I might have to ask my judge afterwards, but I believe the judge is able to control the chambers. I'm sure there's a rules of court, and it might vary depending on each court. So you would want to look up the rule of court on allowing media in. But I think the crux of the question is the sexual assault victim's right to anonymity to a certain degree, because they are testifying about really, really personal facts. The problem, and you would imagine that you don't want them to feel to not have to do that in public, right? The thing is, we have a right, it's a constitutional right to be cross-examine your accuser in trial. I forget the precise constitutional term. So if someone's saying that you sexually assaulted them, you have a right for them to have to be in trial publicly and to testify to those facts. There are protections. If there's children, there's certain protections, but they still have a right to confront the witness. I think that's the right term, is confront the witness. When it comes to media, I don't know. It depends on the court, but I would imagine there's some way to allow some privacy. But courts are supposed to be open and public, and so even a lot of the trials have really sensitive information involved. And I would imagine it's kind of up to the judge's discretion to a certain degree on what the media can show. But I would say in general, the defendant has a right to be confronted, or to confront, as they say, the witness in trial if they're testifying against them and saying that they committed a crime.
Great. Thank you so much. Okay, we have a fun one. Do you have an example of a movie or TV show that has done it right, or at least got it close?
Well, again, this is where me not being a media and film expert would hamper me. There's a lot of things that are, close. I would actually say, so my cousin Vinny is actually a movie that I watched throughout my first year of law school in a class called Civ Pro, or Civil Procedure, because it taught about how cases are litigated. Now, whether it followed precisely the rules of procedure, I don't remember, but I remember my teacher thinking that it was a really good example on how to actually litigate a case throughout the trial process. But in terms of movies or TV that actually show true accurately, nothing immediately comes to mind, to be completely honest. And because, to be even more honest, it'd be boring if it did, because so much of what a lawyer is doing in court is arguing technical things. The most exciting stuff is maybe interviewing, or asking questions to a witness on the stand. And a lot of that stuff in movies is true, right? Attorney is asking some really important questions to a witness. But in terms of the objections and allowing, surprise witnesses, a lot of stuff that I've seen just won't happen in trial. So I don't know if there's a good example off the top of my head.
Excellent. Thank you. Okay, we have 2 questions on Judge Judy and then 2 questions on jury nullification. So we'll tackle Judge Judy
love it.
first.
Yeah.
Okay, so how close is Judge Judy to a true representation of trial, and how would you categorize that as an example?
I feel like I completely whiffed and including Judge Judy in this presentation. So from my understanding, I'm not an expert in Judge Judy, but from my understanding, Judge Judy isn't trial. Judge Judy is basically like a mediation, where she's posing as a trial, but the parties have agreed prior to have her be the ultimate decider of their dispute. So I think it's more akin to mediation or arbitration, where the parties have a dispute and they're going to her because they want to be on TV, and they're saying, look, we don't want to go to court. It's probably even a small claims. Most of those are small claims cases, so under, forget the limit for small claims, but definitely under 20,000. And so they go to Judge Judy or the producer and say, we will have her be the ultimate decider. And so therefore it's like a private contract. So the procedure in Judge Judy is not a trial, right? There's no taking of evidence. She's just asking questions back and forth, because she's acting more as a mediator or an arbitrator, resolving a private resolution outside of the judicial process. So I would consider that as an ADR, an alternative dispute resolution. I think she's great. I think she's entertaining for sure. And I think she is a pretty experienced attorney. She might even have judicial experience as well. Don't quote me on that You can just Google her bio. But I know she's a really experienced legal mind, but she's also obviously very entertaining. So in short, I would say not at all, not at all like a real trial, but it's not supposed to be. It's a private dispute resolution away from the actual judicial process, from my understanding. I've never been on Judge Judy, and I don't plan on being on anytime soon, hopefully.
Awesome, thank you. Okay, so jury nullification. We have a question about it being about the constitutional protections for that, and if a juror can be published in any way for jury nullification.
Punished or published? I didn't know if I
Punished, I'm sorry.
No, you cannot be. Jury duty is like you can't be. Lawyers hate giving absolutes, and it's my job to think of every possible outcome. I can't think of any way that a juror would ever be in trouble for how they vote. They can be removed from the jury. There are strict rules. I don't want to think it's like the jury can do whatever the heck they want, but it's kind of a black box. When you're in the jury room, the parties aren't allowed to know what you're talking about unless there's an argument for jury misconduct. But jury misconduct isn't acquitting someone. It's like looking at evidence that wasn't presented in court, or saying, look, if I were on a jury and I say, look, I am an appellate attorney, I know the law, and the law says this. You can't use your own personal experience. You can only use the evidence that's been presented in trial. And if the judge finds out that you have, you'll get removed from the jury, but you're not going to be fined or sent to jail. You can be potentially fined for not showing up to jury duty. Don't quote me on that as well, but I know you can be held in contempt. There are ways for you to be in trouble for not doing your civic duty if you don't have an excuse, but you're never going to be thrown in jail for that. And there shouldn't be any punishment for jury nullification, because the judge is never going to ask you, why did you vote to convict or not convict? The parties might ask you afterwards. The attorneys often want to ask the jury, what was convincing to you? Why did you think of this? And that's after, but the jury can decide if they want to talk to the attorneys or not. So in short, I don't think there's any way that you're going to be punished, other than maybe in the court of public opinion, right? If it's like, think of the Rodney King trial, right? Those jurors got a lot of heat because they arguably started riots, right? And that was potentially a form of jury nullification. And so even though the jurors' names shouldn't be publicized, sometimes they are found out, and you could get in trouble in the court of public opinion if the public at large disagrees with your decision. But those are, I would imagine, pretty rare instances of when that would happen. I know we only have a few minutes, but if there's any other questions, I'd be happy to answer them as best I can.
Excellent. Thank you. Okay, so we have some that seem pretty specific and may be actually a little bit outside of the scope of what you can handle in the course of this. So,
If there's any questions, I think
yeah.
your email address was up there. You can forward them to me, and if I have the ability, I can maybe respond one-on-one. But
Absolutely. Someone did have questions on the constitutionality of jury nullification. That may be something that we can follow up on that one,
Right.
as far as it goes. Hold on a second. Am I still there? Hello?
I can hear you.
Okay, will do. Thank you. Okay, another question that we have is statutes of limitations, and do they vary as far as different civil and criminal cases and state and federal?
Yes, they do. And a good attorney will know those, but you should always look them up. I said 2 years because I believe that's a lot of the civil claims, like breach of contract and negligence. I'm pretty confident is 2 years. But that varies depending on the type of action. Sometimes the legislature, this is a purely issue of statute. So the legislature can make that shorter or longer. And for criminal, like murder, there isn't a statute of limitations. I'm fairly confident. I'm 99% sure that's right, that there's no statute of limitations. You commit a murder, just like hiding out or whatever for years isn't going to save you. There's no statute of limitations for that. There is for some crimes. The DA, once they know about the crime, they can't just hang it over your head for years. They have to either litigate it or not, or prosecute it or not. But you always want to look it up. or have your attorney look it up.
Excellent. Thank you so much. I'd say we're at time. We will follow up with the questions that we did not get to. There are a few that we still have, so we'll go ahead and follow up on those. Thank you guys for your questions. They are excellent. Kim, would you like to take away the closing?
Yes, and thanks again to Connor for his wonderful presentation. Thank you to Elena and Vanessa for monitoring our Q&A, and thank you all for attending. If you're ever in the area, please visit the State Library in person at 914 Capitol Mall in Sacramento, Monday through Friday from 9:30 a.m. to 4 o'clock p.m. Thank you all for attending and have a great evening.